Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia and I'll be with you for the next hour. As our regular viewers are aware, the free legal advice show provides you, our viewers, the opportunity to call in and ask us any questions that you have on any aspect of English law. On this show, I should be able to cover a vast, diverse range of legal matters. Matters ranging from immigration law matters, family law matters, property law matters. So whatever your questions are, please feel free to pick up the phone and give me a ring on the number that appears at the bottom of the screen. Alternatively, you can send me a WhatsApp message or a text message on the mobile number that appears at the bottom of the screen. Just a couple of minor matters before we get going. Obviously, on a live show, it's not possible to take very detailed information from viewers who call in. If it transpires that your matter is more complex and I need more time to speak to you in depth about your query, then I'll ask you to leave your number with the control room and I will give you a ring after the show has finished. Secondly, just another minor point, if it transpires that I need to look at your documents before I can advise you further. For example, for immigration law matters, we tend to find that where our viewers have received a refusal letter from the Home Office, it's important that I look at the refusal letter before I can give you proper advice. Now, if it's the case that I need to speak to you in depth or I need to look at your documents, then I will ask you to leave your number with the control room and then I will have a more thorough discussion with you after I've had a look at your documents. And this is the free legal advice show. Any advice that we provide after you sent me the documents in, any further advice that you need, there's absolutely no charge to that. So please feel free to send us any information that you want me to give you advice on. We get numerous questions on immigration law matters, which is fantastic. But as always, even if your question relates to other legal matters, please feel free to pick up the phone and give me a ring. And I can hopefully advise you on that. Now, each week we get numerous questions coming in on WhatsApp on that mobile number, which appears at the bottom of the screen. Now, as always, we've had questions that have started coming in already. We've got quite a long question that's come in. So what I'll do is, I've not had a look at this question. I've just seen the question come in on WhatsApp. Let me go through it with you, our viewers, and then let's look at what the advice should be in relation to that. So our viewer is asking that I have indefinite leave to remain in the United Kingdom. Came as a refugee. Initially, the application was rejected. I submitted an appeal, went to court, and the application was granted. Now, and I think it seems like the Home Office then appealed against the successful appeal, and the matter went on. The Home Office lost, but ultimately it ended up with the appellant, the viewer who's texted in, being successful as far as the indefinite leave to remain application is concerned. So that's the background. The question that's been posed by our viewer is as follows. I have no good work history. I know financial and work history is needed for those who are from the EU or the EEA and those who are sponsoring family members. So let's look at the first part of this question, which is our viewer wants to apply for nationality. And the question that's been posed is that he or she doesn't have good employment history. So the question really is that when you submit a nationality application, how important is you having good employment history? Now, the short answer to that is it doesn't matter if you haven't worked, and it doesn't matter if you're not working at the moment. You shouldn't confuse a nationality application with other visa applications where there is a requirement, where there is a financial requirement where you need to be working. So, for example, if you're here on a spouse visa and you're extending or you're applying for indefinite leave to remain, you have to be working. If you're on a work permit visa, a tier 2 visa, a skilled worker visa, then obviously you need to be working. However, you shouldn't confuse those applications with a nationality application, because our viewer here is talking about making a nationality application. And for that, the reality is no employment history is required at all. So even if you haven't worked since you came to the United Kingdom and you're not working at present, you may well be on benefits. That isn't going to make a difference. So as far as the employment history is concerned, you shouldn't be concerned about that. Now, what I should say here is that although I've said there's no requirement that you need to have worked, there's no requirement that you must be working at this moment in time, I should say this, that if you have worked illegally in the United Kingdom, then that could result in your application being refused. So you do need to bear that in mind. So on the one hand, there is absolutely no requirement that you must have worked. But on the other hand, you must make sure that if you have worked illegally and the Home Office are aware of that, then that could result in your application being refused. So you do really need to bear that in mind, that over the last 10 years, although there's no requirement to work, you must make sure that you haven't worked unlawfully in the United Kingdom, because that unlawful work could cause a problem for you. Okay, so the follow-up question that the viewer is asking, and it's similar to the first question that's been posed, is the viewer says, secondly, will my poor work history affect my application for citizenship? Now, as I've said before, the poor work history, if you want to term it as that, won't affect or won't have a negative effect on your nationality application, because there is absolutely no requirement to have been in employment at all whilst you've been in the United Kingdom. So that's the position with that. There's another follow-up question, and that is, will the Home Office retain my passport during the application process? Good question. The short answer to that is it depends on the type of nationality application you submit. You have a choice now when you submit a nationality application. You can submit a paper form, the old traditional way of applying for nationality. You can submit a paper form, in which case all your supporting documents would have to be submitted with your paper-based application. So your passport would have to be submitted, a copy of your English certificate would have to be submitted, if you're married to a British citizen and you're relying on their citizenship as well as part of your application, their passport would need to be submitted. So there's a whole host of documents, actual hard copies, physical documents, original documents would have to be submitted with a paper-based application. However, you now have a choice. You don't need to submit a paper-based application. If you're going to submit a nationality application online, then you don't need to submit hard copies of any documents. You don't need to submit original passports. So you can submit the nationality application online and simply scan a copy of your passport and upload your scanned copy of your passport and leave it at that. You can retain your passport. So hope that answers your question. So in terms of work history, you've got absolutely nothing to worry about. In terms of the passports and whether the original passports need to be submitted, that depends. If you submit a paper-based application, then yes. But if you submit an online application, and nowadays I would recommend that you submit an online application, it's much easier process and you will be able to retain your original documents. You won't need to submit them. Now, just on that, just one sort of practical matter that I should highlight, and that is this: that a lot of times the question about whether you can retain your passport or not is asked because the applicant wants to travel outside the United Kingdom. And that's why they're interested in keeping their passport if possible, because if they need to travel outside the United Kingdom, they want to be able to do that. Now, with a nationality application, if you've submitted the online application and you've uploaded a copy of your passport, there is no problem in traveling outside the United Kingdom. Unlike a normal visa application, there is no restriction as far as nationality applications are concerned in you traveling outside the United Kingdom whilst your nationality application is pending. So the point is you are able to travel, and if you've kept your passport, practically it's easier for you to travel. Now, on that point, I should mention that if you've actually opted for making a nationality application using the paper form, and then you've submitted your original passport to the Home Office, that will cause some practical difficulties for you. Because if you need to travel in an emergency, you won't necessarily be able to do that. Because the problem you're going to have is your passports will be with the Home Office. So you're going to have to request your passports back. And the Home Office aren't always quick in returning your passport. So, and this is what I now advise clients, try and use the online process now for your nationality application. It's a easier, smoother way of applying. You can easily book your biometric appointment. If you've used the online application, you can pay for your application straight away. So there's no problem with the collection of fees later on if you've used the paper form. And the best thing is you can retain your passport so that if you do need to travel in an emergency, you can actually travel. So I would strongly advise that if possible, use the online application in order to make that nationality application. Now, hope that answers your question. Now, if you have any follow-up questions, you're not sure about the advice that I've given, then by all means, please do get in touch with us on the landline number that appears on the bottom of the screen. And as always, we've got a number of WhatsApp messages coming in. So as always, please do continue to send your question in on WhatsApp. We're going to be taking a short break, but after we come back, we've got a couple of questions in relation to spouse applications, and we'll look at that in greater detail after we've taken a short break. Inshallah, we'll be back in the next couple of minutes. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. This is the second part of the show. If you want to speak to me live on air, and if you've got any questions relating to English legal matters, please ring on the landline number which appears at the bottom of the screen, 01924 231 083. Or if you want to send a WhatsApp message to us with your query, then by all means, please do that on the mobile number that appears at the bottom of the screen. So to speak to me live, please call on the landline number, and for text messages or WhatsApp queries, please send those through on the mobile number. As always, we've got a number of WhatsApp messages coming through, which is fantastic. But if you do want to raise any concerns, queries that you have about legal matters, please ring on the landline number. Okay, let's look at the next question that's come in. And our viewer is asking about a spouse visa, and more particularly in relation to the financial requirement. And the question that's been posed is relating to self-employed financial requirement and how that's met. But before I deal with that, let me take the next caller who's online at the moment. Hello, assalamu alaikum. Hello.
Hello.
Hello, assalamu alaikum. Thank you for calling. What's your question?
Hello.
Hello, hi. You're live on air. I can hear you.
Who is speaking, please?
You're live on air. You're on.
Yes.
So you're speaking to.
હું પૂછું છું મારા દીકરા માટે મને એ છે કે તમે ગુજરાતી બોલો છો તે કે કેવી રીતે આવે છે બહારની કન્ટ્રીથી
જી સોરી સર પાછા કેવો તમે ઓકે
હે
જી તમારો ક્વેશ્ચન શું છે જી તમારો ક્વેશ્ચન છે ને તમે જે ક્વેશ્ચન પૂછતા છે તે ક્વેશ્ચન શું છે તમારો
મારા ક્વેશ્ચન છે હું બર્મિંગહામથી બોલું
જી
કે મારા છોકરા અહીંયા યુનાનમાં રહે છે એ સ્ટુડન્ટ છે
જી ઓકે ઓકે
તે કેવી રીતે હું અહીંયા એ દેશમાં તેડી આવું અને
ઓકે એ સ્ટુડન્ટ છે હમણાં
હે
ઇન્ડિયામાં છે ઇન્ડિયામાં
ના ના યુનાન
રાઈટ ઓકે હમણાં સ્ટુડન્ટ છે પણ યુકે આવું છે એને
હા યુકે આવું છે ને
જી
પણ હું મારા એર ના સારું ના હું સુણી બુજી ના શકું ના
જી ઓકે તો એની એજ શું છે એની ઉંમર શું છે એની એજ શું છે કેટલા વર્ષનો છે
જરા ઊંચા બોલો ને તમે
જી તો એનો કેટલા વર્ષનો છે રાઈટ જી થેન્ક યુ
સ્ટુડન્ટ છે ને અહીંયા ભણવા આવીએ ને બારે છે
ઓકે ઓલરાઈટ ઓકે ઠીક છે મેં તમારો જે ક્વેશ્ચન છે ને એનો આન્સર આપો હે થેન્ક યુ તમારો કોણ હારું છે થેન્ક યુ વેરી મચ I think the line's not very clear so it's a bit difficult to understand what's been asked but what our viewer is asking is in relation to son who as I understand it son who's a student and wants to study and what options does he have now assuming that was the question that was being posed then obviously there are a number of options for coming to the UK. I'm assuming the question being posed is how can the son come to the UK? If that's the case, then the son can potentially, if he's a student abroad, he can come here to study in the United Kingdom. Or if he is sponsored by a business in the UK to work, potentially he can be sponsored to work in the United Kingdom. Now, so I'll just answer that question in Gujarati, which is the language that the caller was speaking in. તો આપણો જે તમારો જે ક્વેશ્ચન હતો તમે કહેતા હતા કે સન છે તમારો જે સ્ટુડન્ટ છે તો અગર તમે સનના બારામાં વાત કરી જે સ્ટુડન્ટ છે તો ઇન્ડિયામાં કે બહાર દેશમાં અગર તો સ્ટુડન્ટ છે તો એ યુકેમાં આવી શકે સ્ટુડન્ટ વિઝા પર અગર કોઈ બિઝનેસવાળા એને સ્પોન્સર કરે તો કામની વિઝા પર બી તે આવી શકતો છે તો અગર તમે શ્યોર નહીં મળે મારા આન્સરથી તો તમે તમારો મોબાઈલ નંબર રવા દેજો કંટ્રોલ રૂમના હાથે તો પછી શોના ફિનિશ થઈ જવાના પછી મેં તમને ફોન કરા ઇન્ફોર્મેશન તમારા પાસેથી ત્યારે લઈ લેવા So what I've just said to the viewer is basically what I've said before in English. If the son is a student, he can come here as a student. If he wants to come on a work permit type visa and there's a business that's prepared to sponsor him, that's a possibility. If I have misunderstood the question that's been asked, then I've asked the lady to leave a number with the control room and then I will ring her back and have that more thorough discussion with her off air. Unfortunately, when I was trying to get information from the viewer, the line wasn't very clear, or the lady was speaking very softly, so I wasn't able to pick up all the information. But by all means, feel free to leave your number with the control room and I will have that discussion with you after the show has finished. Just before we took the call, the question that had come in on WhatsApp, which is what I was looking at, was in relation to a sponsor in the UK who is self-employed and wants to sponsor his wife to come to the United Kingdom. And the question that the sponsor is posing is this, that in the last year, because of the lockdown that we've had, my business has suffered a drop in income. And I'm currently unable to meet the £18,600 requirement. Is there any flexibility that the Home Office has introduced which I can rely on in order to sponsor my wife to come to the United Kingdom? Okay, topical question, and this is a problem which is coming up quite regularly in practice, which is people who are self-employed or partners in a business. Normally, when they are sponsoring their partners to come to the United Kingdom, they will be showing their income in the last financial year. So the last financial year, if you're applying now, would be from April 2020 to April 2021. And if you think about it, that sort of corresponds with the lockdown that we've had, the period of lockdown and the restrictions that we've had. I mean, they kicked in around the end of March. So a lot of people who are self-employed are in a situation where when they look at their income from April 20 to April 21, there's been a significant drop in income because of the lockdown and because of the impact of the pandemic. Now, that problem appears to be more prevalent in certain industries. For example, the retail sector has been badly affected because shops have been closed. Those who work as taxi drivers they've been affected because of the restrictions. People have been using taxis less. So certain parts of industry have been affected more. But in certain parts of our industry, they've had a boom period. Takeaways, I think, generally have actually done well. Online businesses have done well as well, whilst the retail sector, the bricks and mortar type retail sector, has been affected. So if you fall, unfortunately, within the former category, where your business has been affected because of the lockdown, your income has dropped, then there is a possibility of sponsoring your husband or wife to come to the United Kingdom with that reduced income. So that is still possible, because what the Home Office has said in their guidance is that if your business has been affected by the pandemic, and then we will ignore your loss of income. So fantastic. There is this quite bold statement that the Home Office has made in their guidance, if you look at their latest guidance. And it basically says, in 2 or 3 sentences, that if you've suffered a drop of income because of lockdown, because of COVID-19, then we will ignore that loss of income. So we won't hold it against you. So on the face of it, it looks like applications where people are self-employed and there's been a loss of income, they will go through. Now, the difficulty I have is that we don't know how this exception to the normal rule, how this flexibility is going to be applied by the Home Office. Now, I think the biggest concern that I have is this, and it may well be that in the coming months we'll see that the Home Office doesn't take this strict approach. But at the moment, the concern that I have is this, that if you've been in self-employment for a long time, and every year your income has been quite low, so you've been earning, let's say, £12,000 per annum for the last few years, end of year 18, end of year 19, end of year 20, you've always only managed to earn £10,000 to £12,000 a year. Now, as before, we've got to year end 2021, and again, your income is £10,000, £12,000 a year. If you then try and argue that, you know what, had it been a proper year, I would have earned more money, I would have met the income requirement, I would have had a problem. My concern is this, that if the Home Office takes the approach of saying, look, you've been in self-employment for a long time, let us look at what you've earned previously. Let's compare. What did you earn for the year ended April 2020? And if you've earned well, and for the year ending April 2021, your income's dropped, we'll accept that because of the particular circumstances we faced, your income dropped. But if they look at your previous year's income, and that's based on the fact that they might ask for it, and if they ask for your previous year's income and they notice that you've always earned under the financial requirement, then what if they turn around and say, well, actually, you know what, as far as the financial requirement is concerned, and as far as your inability to meet the financial requirement is concerned, that's got nothing to do with the lockdown. You've always been unable to meet the financial requirement, and whatever you've earned this year is completely in line with what you've earned in the previous year. So my slight concern with the sort of flexibility that's been introduced is, what additional requirements will the Home Office be imposing on applicants? What will they be asking us to clarify? So although looking at the guidance that's been issued, it's very, very helpful and it's encouraging. And certainly I'd say to applicants that, you know what, if you're struggling, rely on the guidance, put the application in. But always bear in mind, and this is what I advise clients, that we don't know at the moment what the Home Office is going to come back with. Will they simply accept whatever income that you're declaring, and will they accept your assertion that you haven't been able to meet the requirement because of the situation that we've had, circumstances that we've had over the last year? Will they simply accept it without further inquiries? Now, the problem is, at this moment in time, we don't know. A lot of these applications are now going in with the April 2021 period having now come to an end. A lot of these applications are now going in the coming months. So in the coming months, we will find out what the approach of the Home Office is, whether it's a flexible approach, whether they take your word at face value, or whether they will be making inquiries of you and analysing what you're saying. Hopefully that answers your question. We'll be back in the next couple of minutes. We'll be taking a short break. Inshallah, see you then. Assalamu alaikum and welcome back to the Free Legal Advice Show on British Muslim TV. I'm your host, Ilyas Bulbulia. If you have any legal questions that you want to put to us, and you can call us on the landline number which appears at the bottom of the screen. Alternatively, another popular way of getting in touch is to send us a message on WhatsApp on the mobile number that appears at the bottom of the screen. So by all means, if you want to speak to me live, do please call on the landline number which appears at the bottom of the screen. Okay, let's look at the next question that's come in on WhatsApp. And the question is as follows. Let me just read the question out and then we'll go through it. Assalamu alaikum. I am on PIP payment and universal credit due to my disability. Can I apply to buy my council house? Would I lose any of my benefits? So I'm on PIP and universal credit at the moment due to my disability. That's what our viewer is saying. Can I apply to buy my council house? Would I lose any of my benefits? So a specific question about buying a council house and the loss of benefits. Now, normally, so let's look at the current situation. Somebody who is on PIP and receiving universal credit. Now, if you're renting your council house at the moment, then as far as the rent is concerned, that is something which you would be able to recover from DWP. So you would get your rent paid or part of your rent paid as part of universal credit. So if you remember the old system, you used to get job seekers allowance, income support, and then you'd get your housing benefits separately to cover your rent. Now with universal credit, the housing benefit, which was paid separately by the council, that's rolled up into one and you get paid as part of universal credit. So if you're renting your council house at the moment, then if you look at your universal credit payments, you will see that part of the sum that you get, part of that is made up of DWP's contribution towards the rent. Now that might be £300, £400, whatever it is. So at this moment in time, as far as benefits are concerned, yes, you are getting your universal credit, but with your universal credit, you will have in there your rental payments. Now, if you buy the property with or without a mortgage, if you buy the property, obviously you become the owner and then there is no rent to pay to anybody. So you won't be able to recover any rent, or you won't be able to get any rent back. Now, you might purchase the property with a mortgage. If that's the case, you will be making mortgage payments on a monthly basis to your bank or building society. And again, those payments that you will be making on a monthly basis, you won't be able to recover that from DWP either as part of universal credit. So the biggest impact that that you're going to have on your benefits is that there will inevitably be a reduction in the universal credit that you get when the rental payments that you're making now will stop when you purchase the property, and you won't be able to necessarily get assistance to pay your mortgage to the bank or the building society, the monthly payments. You won't get any assistance for that. Hope that answers that question. As always, speak to me live on air. You can ring on the landline number, or you can, as always, continue to send me messages on the mobile number which appears at the bottom of the screen. Okay, let's look at the next question that's come in on WhatsApp. And again, it's a question relating to a spouse application that somebody who's here wants to make, and it relates to how the financial requirement can be met. Now, the question that's been posed is this. Assalamu alaikum. I wish to sponsor my wife to come to the United Kingdom. I am employed. My weekly income varies from week to week and depending on the hours that I have worked. Will that affect the spouse application that I wish to make? Can it still be successful? Fair enough. Okay. Simple, straightforward question. And again, a question that's actually put to immigration lawyers on a regular basis. We've all heard of the financial requirement that needs to be met. And somebody who's gone through the process of sponsoring a partner to come to the UK will be well familiar with that, which is that you need to be earning £18,600 per annum. Generally speaking, although there are exceptions, that income requirement is assessed over a 6-month period. Are you earning 9,300, half of 18,600? Are you earning 9,300 within 6 months? So if it's been assessed over 6 months, we're looking at whether you've earned £9,300 or not. Now, on that, the biggest issue is this. You need to look at whether you're on a fixed salary or whether you're an hourly paid employee like the viewer who's texted in, because the rules for both are completely different. If you're an hourly paid employee like a viewer who's texted in, and the viewer is concerned about the weekly income dropping week by week depending on the hours worked. So if you're an employee who's hourly, like the employee who's texted in, then what you simply do is you simply add up your income over the last 26 weeks and see what that comes up to. If your income over the last 26 weeks comes up to £9,300 per annum, then that is sufficient to meet the financial requirement. So you might have some weeks where, let's say, you've earned £500 a gross a week. There may be other weeks where you've earned only £250, £300 a week. So although you might have some bad weeks, as long as overall in those 26 weeks, or if you're getting paid monthly in those 6 monthly wage slips, as long as when you add it all up together, you get to 9,300, half of 18,600. As long as when you add it all up together, it gets up to 9,300. That is an easy way of meeting the financial requirement. An hourly paid employee doesn't have to be concerned about income dropping in certain weeks. It doesn't matter if you're an hourly paid employee, because it's the average over 6 months, over 26 weeks, which is what you look at. Now, the slight difficulty is with somebody who's a fixed salaried employee. So, for example, somebody who works, let's say, as an accountant, as a pharmacist, on a fixed salary, earning, for example, £25,000 a year. So their income doesn't vary because they'll be working normal hours. You know, it might be normal office-based hours, 9 till 5, whatever it is. So they're earning their normal salary and they're on a fixed salary. Now, the particular difficulty with that type of employment is if in any month the employment drops because you haven't worked, because you've gone abroad and you've taken unpaid leave, or whatever's happened. If your income has dropped and you haven't received your salary in line with your, for example, £25,000 a year income. So if your income has dropped, there's potentially a problem because the Home Office will look at your lowest salary in those 6 months when they assess your income. So if your lowest salary, your salary is dropped to maybe just £1,000 a gross, they will look at that. That's your lowest income. in the last 6 months, they will multiply that by 12. £1,000 is the lowest income, times by 12, that comes up to £12,000 a year, and they will say, we're going to use that as your annual salary. That's the problem. Now, there are certain circumstances where if your incomes drop because you're on sick leave, there are rules which says that wage slip can be ignored, and you can look at not 6 months, you can look at 7 months of wage slip, ignore the one where you've been on sick leave. But generally speaking, if you've taken unpaid leave or if you've not been paid for whatever reason, and you're a fixed salaried employee and your income's dropped, potentially that can be a problem if you're a fixed salaried employee. It's not a problem for hourly based employees. For example, those who work in factories on a production line, etc. Normally they tend to be hourly paid employees. For them, it doesn't matter if it drops in 1 week or 1 month, you simply work out the average. Hope that answers that question. Okay. Let's look at the next question that's come in. And our viewer asks, my parents came as visitors and have now been in the United Kingdom for 18 years. They live with us and we all support them with everything. How can my parents settle in the United Kingdom? So a question about parents who initially came to the United Kingdom as visitors and who now want to apply for settlement in the United Kingdom. Now, from this question, what we can't tell is what the current status is of the parents who are here. I am assuming, and I might be wrong, I am assuming that they came to the United Kingdom as visitors and they have then overstayed. Now, assuming that is correct, that they did come as visitors and they are overstayers and they have overstayed in the United Kingdom for 18 years. The short answer is that they will be able to apply for leave to remain once they have completed 20 years in the United Kingdom. So they won't be able to apply for indefinite leave to remain anytime soon. However, there is a rule within the immigration rules dealing with those who are overstayers. In a nutshell, and I will look at this in greater detail after we come back from our break, but in a nutshell, what the immigration rule in relation to this says is this, that if you've overstayed in the United Kingdom and you have completed 20 years of residence, it could be legal residence, illegal residence, mixture, or it could be completely unlawful residence. Once you've completed 20 years of residence in the United Kingdom, you can apply for limited leave to remain in the United Kingdom. Now, a number of issues arise here, which I need to explore and explain, but we'll do that after we come back from our short break. We'll be back in the next couple of minutes. See you then. Assalamu alaikum and welcome back to the free legal advice show on British Muslim TV. I'm your host Ilyas Bulbulia. To speak to me live on air, you can please ring on the landline number that appears at the bottom of the screen. And as many of our viewers do, if you want to send us a WhatsApp message with your question, please do so on the mobile number that appears at the bottom of the screen. Just before the break, I was looking at the question relating to our viewers' parents who are in the United Kingdom, and they've been in the United Kingdom for the last 18 years. They came as visitors, and it appears to me from the question, although the question is quite brief, that they are overstayers at the moment. So the position is this, that under the current immigration rules, once they've lived in the UK for 20 years, they can both apply for limited leave to remain in the United Kingdom. If that's successful, they will get a 2.5-year visa, and that visa will need to be extended every time it comes to an end after 2.5 years. You'll have to continue doing that until they've completed 10 years of legal residence in the United Kingdom. So once they've completed 10 years of legal residence in the United Kingdom, it's at that stage that they will be able to apply for indefinite leave to remain in the United Kingdom. Now, when you apply for a limited leave to remain after parents have completed 20 years, it's although it's a relatively simple application, what you have to bear in mind is you still have to prove to the Home Office that they have lived in the United Kingdom for 20 years. So they won't simply accept at face value when you say that they've been here for 20 years. You will have to prove that they've been here for 20 years. So you'll have to show their original passport if you have it, showing their entry into the UK. And then how do you prove that they've been here for the last 20 years? If they've got bank statements, if they've got bills, or if they've been seen a doctor, the doctor might have medical records. So if you have evidence, you'll need to submit evidence to prove that they've been here for 20 years. And if you're able to do that and the application is successful, then they will get a 2.5-year visa. And obviously that has benefits, as in they'll be able to leave the UK, come back in again, they'll be legal, etc. The downside to the current rules, or the problems with the current rules, is that once you get this visa after 20 years, you have to complete another 10 years of legal residence to qualify for indefinite leave to remain. So all in all, you've spent 30 years in the United Kingdom before you qualify for indefinite leave to remain in the United Kingdom. Hope that answers the question. Okay, let's look at the next question that's come in from Brother Naeem from Bristol, who sent his question in. Question relates to Tier 2 visas. Brother says, I have two questions. Number one, if my visa is finishing in November 2021, but I have completed 5 years as a Tier 2 migrant by April 2021, can I apply for indefinite leave to remain, or do I have to wait for the 6 months which are now left on the visa to expire? So question is, can you apply now that you've completed 5 years as a Tier 2 migrant? The short answer is yes, you can apply now. You don't need to wait until your visa comes to an end, because the way Tier 2 visas work is when you initially applied for a visa to come to the UK as a Tier 2 migrant, or even if you extended the visa here as a Tier 2 migrant, you would have been granted a 3-year visa initially. After that, if you've applied for the extension, you would have got another 3-year visa. So all in all, it's 6 years. But actually, as far as indefinite leave to remain is concerned, you don't need to wait until the end of that visa. You don't need to complete 6 years. What the rules on Tier 2 settlement state is that as long as you've completed 5 years as a Tier 2 migrant, you can apply for indefinite leave to remain in the United Kingdom. That's quite clear cut. Once you've completed 5 years, and you have now completed 5 years because your Tier 2 5-year residence comes to an end in April 2021, you can apply for indefinite leave to remain. Now, that's the first part of the question which has been posed to us. The second part to the question is this, and our viewer asks, if I have completed 5 years with a Tier 2 visa, do I need a certificate of sponsorship to apply for indefinite leave to remain? So you've completed 5 years in the United Kingdom. Do you need a certificate of sponsorship, a COS, when you apply for indefinite leave to remain in the United Kingdom? The answer to that is no, you don't. So, and I quite understand why you're asking that question, because you would have required that certificate of sponsorship when you initially got the 3-year visa. You would have required a certificate of sponsorship when you extended your visa. However, when you apply for indefinite leave to remain, there is no need for a certificate of sponsorship. However, what you do need is a confirmation of employment letter from your employer. So your employer does need to confirm in a letter certain things. So there's a certain format for the letter that your employer, your Tier 2 employer, needs to complete. So the employer will confirm you are employed. There is a need for your continued employment in the same role with the employer. the employment letter will confirm the SOC code, the SOC code applicable to your employment. The letter will confirm that what your salary is. The letter will confirm that the salary that you are on meets the SOC requirement. The letter will also confirm that if you've been outside the UK, the dates that you've been outside the UK and that you were on annual leave, or there was some other valid reason as to why you were outside the United Kingdom. So in answer to your question, although there's no requirement for a certificate of sponsorship as such, there is a requirement that your employer has to do a letter with certain information. So it's not just a simple letter which says, yes, you're employed and we need you. There are certain pieces of information that have to be included in the letter. You're employed, the role that you're employed in, the job's going to continue, your SOC code, your current salary, confirmation that the current salary meets the current SOC requirement, your absences from the UK and the reason for those absences. So there's a bit more to it than submitting a very basic employment letter. You need to get the employment letter right. Hope that answers your question. Okay, let's look at the next question that's come in. And from our viewer who is asking, Assalamu alaikum, the question is, how long does the first hearing answer take for an immigration matter? So, brief question. What appears to be the issue here is that our viewer, it looks like, has been involved in an immigration appeal hearing and wants to know how long it will take to get a decision after that hearing. Again, in practice, lawyers get asked that regularly, and just this morning I was dealing with a client who'd been through an appeal hearing, very anxious, waiting to find out, what the decision is. And sometimes what happens is you attend the hearing and the judge says, look, I've looked at everything, I'll get you a decision within 2 weeks. So you've got this time frame in mind, you're expecting a decision within 2 weeks, and it doesn't come through, and you think, look, something must have gone wrong. Have they sent it to the wrong address? Or is my appeal going to be refused? What's going on? Now, first of all, let me give you a general idea as to how long decisions do take to be issued to applicants or sponsors. Generally speaking, in my experience, it takes 2 to 3 weeks for the tribunal to get their decision out to the parties. So 2 to 3 weeks is generally a good time frame to work to. There are circumstances when obviously it's not going to be possible to meet that requirement. Now, there are particular problems at the moment with the lockdown and certain members of staff in offices self-isolating, working from home, judges may be self-isolating, etc. So it's inevitable that there's going to be some kind of delay in the tribunal getting its decision out. So if the tribunal is busy and the typing pool where the judge's decision goes to be typed up, they're short-staffed. Or if the judges have to take time off because they're unwell or family members unwell, that's obviously going to have a knock-on effect on this 2 to 3 week time frame that I've suggested. But generally speaking, 2 to 3 weeks is how long it takes for the decision to be issued to the parties. Now, let's say you've waited, 3 weeks have passed, 4 weeks have passed. What can you do? A couple of things that you can do. First of all, pick up the phone and call the tribunal. There is a contact centre number there on the notice of hearing. I think it's a Leicester number. Ring that and ask them whether a decision has been issued or not. They can't tell you what the decision is. So they can't tell you whether the application has been successful or not. But what they can tell you is whether the decision's been issued and when that decision was issued. Now, if they turn around and say, look, you know what, your decision was issued a week ago and you haven't received it, then clearly something's gone wrong somewhere. That post has got lost. Or if they say decision was only issued 2 days ago, you know you have to wait. You should be getting the decision within a couple of days. So if they say, look, you know what, according to our notes, it's still with the judge and it hasn't been issued, you know that nothing's gone wrong. It's simply a case of the decision not having been issued. Now, if the decision's not issued, a couple of months go by and it still hasn't been issued, what can you do? You can write to the tribunal and mark it for the attention of the duty judge, or mark it for the attention of the senior judge and say, look, you know, my hearing took place on this date. I haven't had a decision. I'd be grateful for an update. The judges, the tribunals do write back. And if it's the case that there is a problem in issuing the decision, they will write back and tell you and hopefully give you an indication as to how long it will take before you get your decision. Having said all that, in my experience, 2 to 3 weeks is how long it takes for the decision to be issued. Hope that answers your question on how long it takes to get a decision back. I think the times are such at the moment that we all need to be slightly patient. That brings us to the end of the show. Inshallah, we'll be back next week on Tuesday at 4 o'clock. Until then, Assalamu alaikum.